Well, this idea that you had a right to earn a living was then considered one of the privileges or immunities of citizenship, and when the Constitution was written, it included a clause that protected the privileges or immunities of all Americans. That was not in the 14th Amendment, that was in the first part of the Constitution, Article 4. And in a case called Corfield versus Coryell in the 1820s, Justice Bushrod Washington, who is the nephew of President Washington, said that this included the right of economic liberty. Well, after the Civil War, then the 14th Amendment is written. Right? Did anybody remember what year the 14th Amendment was written? 1868. Right? 1868 was when the 14th Amendment becomes part of the Constitution. And the 14th Amendment says no state may deprive any person of the privileges or immunities of citizens of the United States. And that included the right to economic liberty. Unfortunately, in 1873, in a case, it was the first U.S. Supreme Court case ever to interpret the 14th Amendment. It's called the Slaughterhouse Cases. The Supreme Court basically erased this clause from the Constitution. What happened was the state of Louisiana passed a law saying if you want to slaughter cattle, you have to do it at one privately owned butcher shop in New Orleans. Just happened to be owned by members of the state legislature. Right. Now this is a major deal because the cattle industry in New Orleans in the 1870s is huge business, right? For the ranchers bring their cattle down from the Midwest on the Mississippi River, or they bring them over from Texas. They're slaughtered in New Orleans, put on ships, and sent to markets in Europe or on the East Coast or whatever. So this is a big deal. I often say you'd have to imagine like if the state of California said that all automobiles in Los Angeles County had to be repaired at AMCO. Right? It would put all these private garages out of business overnight, and that's what happened. A lot of these butchers had to close up shop, and so they filed a lawsuit, and they said the Constitution says no state can deprive us of the privileges or immunities of citizenship. The privileges or immunities of citizenship include my right to earn a living without having to face these government-created monopolies. Nevertheless, the Supreme Court refused to enforce this right and said, no, the privileges or immunities clause, it's true, you have a right to earn a living, but that right is a state-protected right, and the privileges or immunities clause only protects certain federal rights, such as your right to travel on the high seas. Yeah, because that's what was on the mind of the abolitionists in the 1860s, right? Was that former slaves from the South were trying to travel on the high seas, and the state of Arkansas was stopping them with its navy. Of course not. That's ridiculous, right? The Privileges or Immunities Clause was intended to protect certain fundamental rights, including the right of economic liberty. Nevertheless, slaughterhouse remains good law today. And since that day, with only a few minor exceptions, the Supreme Court has never enforced the Privileges or Immunities Clause of the 14th Amendment. Okay, so erase that from your minds. The next argument that we made was that the Pigeon Law, we said it violates the Due Process of Law Clause. Now, the Constitution says you cannot be deprived of liberty except by due process of law. What does that mean? What does it mean of law? What is a law? Well, philosophers have obviously debated that issue for a very long time. But one thing that we do know about law is that it is the opposite of arbitrariness, right? Law means the use of government's coercive powers in the service of some overall principle that protects the general public, that advances the public good in some way. Not just because the lawmaker or the king or the legislature felt like it, right? I often say if any of you have kids and you've ever told your kids, because I say so, you're violating the Due Process of Law Clause, right? Because simply saying, I'm the government, you have to do what I say, is an arbitrary act. That is not lawfulness. That's not what we mean when we talk about law. Law is a general principle, right? And we know that the Constitution requires the government to act in a lawful way. The Constitution says government can't act just arbitrarily, just because it wants to. And there are certain boundaries on what constitutes a law and what doesn't. So imagine for example, that if Congress were to pass a law tomorrow that said Scientology is the official religion of the United States and you're all required to go to the Scientology church. The weekend comes and you don't go. Sheriff knocks on your door. Why aren't you in church? You'd say, well, I'm not a Scientologist. He said, oh, yes, you are. Right? Congress passed this law. And you would say, no, they didn't. Congress can't make a law on this subject. The First Amendment says Congress shall make no law on this subject. So whatever Congress did, it passed an announcement or a pronouncement or a dictate, or you can call it whatever, a non-binding resolution. You can call it whatever you want, but you can't call it a law. because Congress can't make law like this. And if the sheriff then arrests you and takes you to jail, he's depriving you of liberty without due process of law. Everybody with me? Right? Make clear? Okay, so now that principle applies if we're talking about an explicit prohibition on what the government can do. What about certain implicit prohibitions? There are certain basic implicit prohibitions on what government is allowed to do. And to understand this, you have to think like the Founding Fathers did, right? The Founding Fathers thought of government as like a bank guard. Right? So suppose that you owned a bank and you're afraid that somebody's going to come and rob your bank, rob your bank. So you hire a guard to stand in the corner of the bank with his badge and his gun. Now problem solved, right? Not really. Now you have a new problem. There's a guy with a gun in your bank, right? And he could very well take out the gun and rob the bank for himself. Right? And what happens if your bank guard robs the bank for himself? What are you going to do? You're going to say, you can't do that. You're my guard. You're not supposed to rob the bank. And he would say, where's that in the contract? You didn't say in the contract that I couldn't rob the bank. And you would say, well, duh. The whole point of hiring a bank guard was to protect my bank from being robbed. The exact same principle applies to the government. If the government uses its coercive powers to deprive you of the very rights that government exists to protect, in order to benefit itself, or in order to benefit a favored private interest group, what it's doing is fundamentally arbitrary and therefore violates the due process of law requirement in the 5th and the 14th Amendments. That is the theory that today lawyers tend to call substantive due process. I hate that term because when you look at the actual cases, they never use this term. Right? One of the great cases on this is a case called Loan Association versus Topeka, from the 1870s. I love the Loan Association case because it's just a fascinating case. Unfortunately, a lot of law professors and law students today just have no respect for the 19th century judges, and I think this is a shame. If I could wave my magic wand and change one thing about law schools in this country, it would be to restore respect for the 19th century judges who really understood these things very deeply, and we tend to ignore them nowadays. But what happened in Loan Association versus Topeka was the court was confronted with the question of whether government can take taxpayer money and buy bonds in a privately owned railroad. Now, if you were to argue that that was unconstitutional today, you'd be laughed out of court. But the Supreme Court not only listened to that case, but found it unconstitutional. It said all government is doing here is taking money from some people and giving it to other people. And that is unconstitutional. It violates our protections for private property rights. It said, in fact, to take from A and give to B is no less a robbery just because it is done under the forms of law and is called legislation. This is not a law, it is a decree under legislative forms, not a law, which means it violates the due process of law clause of the Constitution. Now, these principles were well understood in the 19th century and at the beginning of the 20th century. And there was a case, of course, many people in this area are familiar with the case of Lochner versus New York. Now, all the lawyers or law professors on you are supposed to go, boo, whenever I mention Lochner, because Lochner, evil, evil, it's the worst decision ever. Right? I love Lochner. In fact, my license plate is the case citation for Lochner versus New York. What happened in the Lochner case was the state of New York passed a law that prohibited bakers from working overtime. Okay, it passed a law saying bakers are not allowed to work more than 10 hours a day. Now, this was 1905, and none of us would want to work in a bakery in New York City, or Utica, I guess it was, in 1905. None of us. It's a miserable job. But it was the best opportunity for a lot of people, and particularly for the European immigrants who were flooding into New York City at that time. And one of these men was a German guy named by the name of Amann Schmitter, who wanted to work more than 10 hours a day in the Lochner bakery. Now, why would a German immigrant want to work more than 10 hours a day? Obviously, he was being exploited by evil capitalists, right? So the state of New York, being, the legislature being comprised of good-hearted liberals, what they decided to do is to deprive him of the economic opportunity that he needs, and then not pay him for the lost wages, and then pat themselves on the back for how sweet and kind they're being to the poor. Because that's pretty much what liberals do, is they take away a person's earning power and then congratulate themselves for helping the poor.